Yeah, so anything before April 17th, 2021. Go ahead and confirm that. That's a Saturday. So anything before April 16th, 2021, most likely did not fall under this 2022 complaint. And I know you had a number of dates in here, Ms. EIRSCHELE, and I believe you amended your complaint in one, which was time barred, and on this one, it was a new complaint. Some of them were post-termination issues, some of them are termination. You might have some claims that were before termination. So I'm going to note just the time frame. So, Ms. EIRSCHELE, it may be possible that some of this disability issues are falling under this complaint.
Is this one not? So I filed a new complaint, but it's not. It doesn't go along with the amended. Like it's not part of the original complaint.
So you did two things. You had filed a complaint back in 2020, April 24th, 2020 with the EEOC. They opted to dismiss the case and gave you your notice of right to sue. You asked the ERD to investigate. During the course of that investigation, I'm assuming the ERO asked you follow-up questions. You amended that complaint. I think it was probably around the same time. You separately filed this complaint after you were terminated, it looks like. This complaint, CR 2022-00512, is a new complaint, and anything within the statute of limitations can be brought. And I don't think there was technically a statute of limitations issue raised on this one. I think it was a lot of post-termination matters, and there might have been an attack on particular claims.
But it's not as though this gets attached to the other one. I don't know if it's
no, it didn't.
I thought
So
it was
you
like an
tried.
amendment.
So you tried to do that on your first one. You did an amended complaint. That was the challenge. Was that it was beyond the statute of limitations and it did not relate back to your original complaint. So just because you have a complaint doesn't mean that you can just amend it at will. Generally speaking, the claim should fall within the statute of limitations. If they don't, it's possible that they can relate back if it deals with the same facts and circumstances, but yours wasn't, because you were claiming that you were retaliated against for filing race-based claims, and the amended complaint dealt with disability claims, and they were at different time periods, if I remember correctly. So they were dismissed in that amended complaint. Those claims were dismissed. But here in this complaint, you've raised some disability related. Now, I'm assuming most of it is termination. I'm sure this complaint dealt mostly with termination, but I think this document was in both. So you were probably dealing with them around the same time.
Okay.
So
yeah, it's all kind of gets mixed together.
yeah, I mean, at this point, you've mostly fully testified yesterday. I know you're filling in more details. I did want to clarify that still, to the extent that you're claiming retaliation, I don't need every little back and forth detail unless you feel like it's relevant.
Okay.
And Judge, just so I understand the ruling, I believe you said that the disability discrimination, nothing before April 16th of 2021 is coming in, but afterwards can be discussed?
Right, based on and I don't believe there was a statute of limitations issue raised by the respondent, and I'm assuming that's because there were no claims in this one before the statute of limitations. I'd have to look again. I know Attorney Simcox, I don't know that you were the one that raised that.
April 24th of 21. Is that correct?
Your first complaint was 2020.
Right.
Yeah, so if I'm remembering correctly, the motion to dismiss on the 5/12, part of it was post-termination issues that the respondent believed couldn't be raised. Part of it was that the respondent believed the motion to dismiss on 10/29 would resolve the issues. I don't believe there were any statute of limitations concerns. So I think there were no claims raised prior to that in 5/12 is my understanding. I don't know if the parties disagree with that.
I don't know.
Yeah, because your complaint, do I still have it open? Yeah, I mean, we'll definitely have to clean it up in the end, but yeah, anything before that date I indicated, which I just put in my notes, April 17th. Well, I put April 17th, but I said the 16th, right? Because the 17th was a Saturday. I'll have to count that, I guess, the other way. Let me do this. So 4, 16, 20, 21, 300, 210, 22. Yeah, it would have to be April 17th, even though that's a Saturday, counting forward. So April 17th, 2021, anything before that, I believe is excluded under the decision and order on 10/29. Claims in the amended complaint were dismissed as time barred. And to the extent anything is raised in 5/12, if they're timely, they could be considered. I viewed 5/12 as mostly concerning your termination, Ms. EIRSCHELE. I don't know if you disagree with that. And then some post-termination issues.
I don't know. I think I really honestly I get them all mixed up with the amount of motions to dismiss and the appeals I've had to do, and with all of these, the EEOC ones, the unemployment, like it's all, I don't understand it. And I think I probably thought that I was amending my one complaint and that they all were covered under the original EEOC complaint I made because they were dual filed. And so I'm not that familiar with the process, and I don't know. I was just trying to advocate for myself and for the kids. So.
All right, well, we can continue, and the decision and orders were as they were stated. And again, to the extent you believe anything was incorrect, that may be an issue on appeal if you're unsuccessful in this hearing. But you filed really multiple complaints, and that was kind of the subject of your statute of limitations motion that you'll get a decision on, where that was a separate Wisconsin whistleblower law complaint that you filed. There was a determination of no probable cause there, and that was not appealed. So you have multiple complaints. They more or less stand alone. I know these two, they're related. That's why we consolidated them for hearing. But for 10/29, you tried to amend the complaint, respondent challenged them. They were untimely and did not relate back to your original complaint, because your original complaint was retaliation for making race-based complaints. So any sort of amendment, if it's not timely, would have to relate to that. But you have 5/12, which I mostly view as termination related. You might have some terms and conditions in there.
I think part of it too, though, to be honest, is like I thought everything was covered under my EEOC complaint, and that when these determinations were filed, was there a case where my EEOC complaint was still valid before Weitzman was closed or decided?
So you have one complaint that you filed in January 2020 that you raised in your
Yes.
latest motion. That's a Wisconsin whistleblower law claim. You raised that with the ERD, not with the EEOC. You claimed the respondent violated the Wisconsin whistleblower law for state employees. That one, there was no probable cause. You did not appeal it. Maybe because you thought it was all related. In April of 2020, you filed an EEOC claim for retaliation. So January was the whistleblower law. April was this one for retaliation. And then somewhere in the course of that, you attempted to amend that complaint. You also filed a separate complaint. I don't know if you feel like that was not your intention, but I have that one issued. You submitted it on February. You signed it February 1st. We received it February 11th. Is what I have as date stamped.
Okay.
That one, again, looks like it was mostly termination issues, some post-termination issues, maybe some terms and conditions, right before then. So for our purposes, you have 3. The one that you filed with the EEOC, they dismissed.
Yes.
They
I
gave
had
you a right to
been-
sue, right, and then you asked us to investigate it. So you had, as far as I can tell, that one. For 512, that one is dual filed with the EEOC. They are waiting, right? You're pursuing it here with the ERD. So that one, in theory, is still before the EEOC, potentially. So the first one, because there is no federal component for the Wisconsin whistleblower law, that's only ERD. The second one, EEOC dismissed. The third one, they're just kind of holding.
Okay.
All right. All right. We'll obviously clean it up to the extent there's disability related items that were dismissed as time barred under 1029. Those are still dismissed as time barred. You may have some disability terms and conditions, it looks like, under 512 that were probably close to termination. But otherwise, it looks like 512 mostly concerned termination.
Okay.
All right. All right. All that was on the record. We are still recording. You want to continue with your testimony?
Yes.
All right.
Okay, so my 2 training requests were denied. They were withdrawn. One was by Colonel Moore. So I had gone up the chain, and I had not been given notice of me not being eligible for training prior to my applications. And my supervisor had encouraged me to submit those training requests, even though it was during our busy time. And one of my coworkers did go. She went to Alaska. Let's see. Yesterday I had quoted the serious incident report quote. If you go to ERD 0658, it's stated on there. That's where I got the information from. It doesn't give a reason as to why. I believed at the National Convention, they had mentioned that it's one way to prevent any, basically to be able to control any information if there was an issue like a press release due to some type of negative event happening or something, a way of controlling that. But that's what I just had understood. The reason to be
All right. 1 second, let me grab that to make sure. You said 0658.
correct.
Okay, so that's already into evidence. Is that correct?
Yep. That was part of the where
Cooperative agreement.
Yes, the federal employee portion. And just to clarify, the training that I understood the cadet majors to be under training because she was at the academy program in the residential phase, which is the training portion. And so I understood her to be covered under that. And by me reporting any type of mistreatment or discrimination, that not only she would be covered under law, but I would be covered as well.
Are you you said 0658,
Right.
which was maybe that's the one you wanted, the hands off.
Yes, it's the same section of information. So the hands-off policy also would apply to not being adhered to, but for this purpose, I'm talking about section 1 to 13. I didn't even see that before, to be honest. Well, yeah, 113. I didn't see the 14 when you were scrolling. I thought maybe that there was more information, but this is all the information I had yesterday that I presented. So
Right.
I just wanted to clarify and show that's where I got the information from. I don't know if you need it to be on as an evidence. I just had made a note yesterday about it.
Okay.
Could you please go to 680?
Is that the one? ERD 680. It looks like it might be. I don't know if it's 2 pages or if that.
I don't know what happened with that one page where it has all kinds of characters.
Yeah.
This is just the training policy.
Through 685 or.
I have 680 to 685.
Okay.
Yes.
All right. So go ahead. Sorry.
It says, so this is just the training policy. They also, more detailed is in the full cooperative agreement as to the professional training that I should have been allowed to and approved to receive. One of the things that is, if I'm not given any professional training in advancing my skill set in my position, that it would go against the cooperative agreement, and that they're encouraging staff to be able to have the skills needed to perform their job, to be able to help intervene in the lives of at-risk youth. And then it states that failure to provide professional development training opportunities for the program directors / staff will result in a significant findings during operational site visits / evaluations, and will be jeopardized future program funding until the situation is corrected. So the training portion, when I was denied, that was pretty significant act of retaliation and discrimination towards me. Could you please go to 593, and it goes all the way to, I have it noted as going all the way to 632, and I may have this might be a duplicate or one that I've already asked to be as an exhibit, but could you please go to 593? So this is an email to HR about another act of retaliation and about some concerns I have and about the letters of expectation I received and information I about my phone call to Neindorf. And so I'm sending, I think let's see.
You believe it goes to 597?
632.
Okay, so this
So it's an email and then there were attachments.
attachments.
Yeah.
Okay, we definitely did not cover all of them. If that's what.
No. So it's just, let's see. This is
These
just
were
information about, this is taking place during the investigation. And so I was just showing that it's another act of retaliation and discrimination that I was subjected to. So if you don't want to put the whole thing in, could you please at least put 593 to 595 in as evidence, please?
well, Attorney Simcox, I guess that's the original request, 593 to 632. Looks like
There's no objection to this being admitted.
Alrighty.
Thank you.
Did you move 680 to 685?
Yes, could you please also put that as evidence? Thank you for clarifying.
Attorney Simcox.
No objection. I'm sorry, can you please clarify the Bates numbers, the start and the end? I think the end is 632 on this last one we admitted.
Yep,
Correct.
that's what she indicated. I know I haven't even gotten that far as scrolling. But yeah, that's what she indicated. Okay.
Yeah, we're familiar with this. There's no objection.
Okay. All right.
Could you go please to 674?
Six, 7, 4.
Correct.
One.
It's one.
How many pages? Three pages to 676.
Yes, I believe. I have a note on. Could you scroll up just a little bit?
Up here.
Down or down. Sorry. That highlighted portion, I believe, any person believes that they have been discriminated against or who has knowledge of any type of illegal behavior should report such conduct, and that you have the right, you have a responsibility to make a complaint to DMA or wing. So I just wanted to make sure that that's noted. I did my due diligence in making those complaints, not only with regards to my concerns with the treatment of the cadets and or participants, but also in alerting my supervisor, management, and HR about my work environment and my health, which isn't part of this, I guess. So
And I'm just going to object at this point too to for timeliness. A lot of this is getting into argument. I don't object to pinpointing these exhibits, but
Mhm.
much of this should be reserved for closing.
Yeah, I mean, I get your point, Attorney Simcox. So generally speaking, Ms. EIRSCHELE, you testify to things that happened and not necessarily. So right now you're trying to make an argument, right? So you're showing this, but then you're trying to say, well, and so it was retaliation because of X or Y. So I get it. I'm gonna be a little flexible, but generally speaking, Ms. EIRSCHELE, yeah, if you can reserve argument to the end.
Okay. I didn't I made a closing statement, but I didn't put in all the policies and stuff that
Yeah, I don't. So at the end, I don't need it, right? So that's why this is the testimony part is where you're putting in all those facts and details. You know what happened. Um, I'm okay with some of it. Frankly, it probably helps sometimes if you clarify. So Attorney Simcox, I note the objection. I'll be a little lenient, but definitely don't stray into just straight. Some people sometimes just stray into straight arguments. Yours at least are trying to be fact and argument, and I get your point, Attorney Simcox, but it's probably helping more than hurting. You can go ahead, Ursula.
Okay. Could you please go to? I'd like to move this into evidence if, yeah, I'm not sure if it's needed or not since it's a policy or program memo.
Yeah, so I mean, policies generally you would want to move into. You don't need to move in like statute.
Like this
Or,
type of
you know, this,
document?
yeah, but something like this, I would say you would want to move in. Attorney Simcox,
No objection.
it's admitted.
All right, and then now we're just going to my termination. If you go to 573, please. And that goes to 577. It's an email chain between HR Meyer and myself following my termination. It also contains the termination letter.
Five 573
Yes,
and to 577.
yes.
All right. Where do you want to start?
So I'm just in the email, I'm trying to clarify what was deemed as malicious and that the malicious act, and it's super tiny. I'm not sure if I had my printing settings reduced or why it's so tiny. But I'm trying to seek clarification as to what was deemed malicious and how it was applied, because it had to do with the state of Wisconsin and having a malicious attack on my employer. But HR Myers had deemed Julie Katona as my misspeaking of her in regards to her comments towards me during our phone call that I made with Tracy Neindorf during FMLA. That was deemed as malicious, an attack on my employer because she worked for my employer. So I thought it was a far stretch. Didn't seem reasonable. I didn't really understand the RIC rule violations and what they applied to, that they considered applied to each. So what action did I actually do for each rule violated is what I was wanting that information for. But I was told to basically just go search in the investigation documentation. Okay, so let's see.
No objection if we're moving to enter this.
Thank you.
Right.
So some of the documents I have that I had included in are more procedural type documents. Do you want me to just give you the Bates numbers and description of what it is? Or how would it be best to
Sure.
do this? Okay.
Start,
So
yeah,
I
one at a
have-
time. I'm still going to pull them up so that
Okay.
Attorney Simcox can see it. Go ahead.
So one is 646 to 647, which is policy 314. And it's dated February 25th of 21. So the equity and inclusion plan.
646 to 647. Attorney
Yes.
Simcox.
No objection.
Any?
And I have the same document notated a second time, but it has a date of April 23rd of 2018. I'm not sure if that matters or not. I have it noted because of when a lot of the situations had occurred prior to this February 25th, 21 notice, and we hadn't been notified of the all the changes that were happening with the handbooks and the policies and procedures. And so I'm not sure if it's worth noting or not, but the other date that document is dated ERD 689 to 695. So it's the same policy, but it's just a policy that was created prior to that one.
689
to 695.
All right. Attorney Simcox.
No objection.
Alrighty. Submitted.
I believe I submitted this one already, 68068 to 685, the training policy. I believe I just did that one. Is that correct?
680 to 685, you said?
Yes.
Yep.
Okay. 663 to 665. So that's a hands-off policy.
Give me the numbers again. 663
to 665.